What's up, everybody? It's Stephen A. Williams, president and founder of the creditrepairshop.com. I wanted to go over this summons um, that was actually posted in a Facebook group that I'm in. So this individual wanted this information to be able to be utilized. I'm going to cover up their name, though. This one here is actually from this individual got a judgment, and they live in the state of Texas. And what I want to talk about in this video is number one, once it gets to this position here, really your only options is to see if you can get it reopened. And you have to look in your particular state, look at the state laws that for debt collectors that are what is required of them when they take you to court. If they serviced you, some states say that they have to serve you a certain way. Some states say that they have to just attempt to service and prove that they attempted to service. The next thing that you would want to do is to see if you could just reopen it because you didn't show up to court the first time, and you have to have a reason that the judge will believe that the outcome could be different. You can't just ask to have it reopened just to have it reopened. There has to be a specific reason that for evidence that you're going to present to either make a difference in where it wouldn't be a judgment or to maybe change the amount. And we're going to talk a little bit about that in a minute. Now, moving forward to what I see here, this is where they want a discovery to aid in how they're going to try to collect the money from this individual. Now, what you can see the questions that they're having them here. They said admit that you have an ownership interest in one or more bank accounts. They're trying to get this individual to admit that they have a bank account or one or two or whatever. They just want them to say yes to it. Admit that you own assets which are not exempt from execution, seizure, or attachment. In the state of Texas, one of the things they have a lot of exemptions. All states have a lot of exemptions unless you're a business owner. They have a lot of exemptions, and like they can't take your car, they can't take certain things from you. If you own a home, they may be able to put a lien on your home, but they can't take the home. They'll just try to wait until you sell it, and that time frame is 20 years on that actual their ability to be able to take the money from the sale of your home. So if an individual is not looking at selling their home within 20 years, they're going to be out of luck. But they're looking for assets. And the reason why they do a sheet like this in Texas is because they can't garnish your wages in Texas, but they can seize bank accounts. So like it's a benefit, and then there's not a benefit in Texas. So they can't just go to your employer and say, hey, we want to start taking money out of their paycheck. They can't do that, but they can see in some cases they can seize money right out of your bank account. So that's why they're asking these questions. They admit that you have funds that you have in a bank account that are not exempt. Now, some of the things that could be exempt is if it's a combined bank account with even with your spouse that is not named in the judgment. So if they just had you named in the judgment or this individual named in the judgment, they cannot attach that bank account. It would be exempt, or they may only be able to take a portion of that account. Now, admit to the balance of the judgment is unpaid. Now, again, if this is a judgment, I don't know if it was a default judgment, but that's what they're stating. Now, this would be a reason to reopen it, is because you could say, number one, do what I told you to do at the beginning to see if you can get it reopened and have it set aside because you have evidence that could differ than what they're stating, and you would put your response here because you still have to fill out this paperwork to get it to the court and to the plaintiff attorney. And then here, admit that there are no credits, offsets, payments which you have made that will reflect in the balance owed on the judgment. And this would be where you would, start building your case to have this looked at, which I'm going to go into in a minute. This here is, they're just trying to see what person is owed. This is a document that is required state of Texas, and they may utilize this to actually exempt the individual from being able to even have their bank account attached. And then these were some more questions that they were asking. They were, if you look here, let's see, go right here. They were, you have funds deposited in any savings, trust, or checking held jointly or with someone else. If so, you have to name because they want to see, try to figure out if it's, if they're going to be able to attach it. Here, they're talking about stocks and bonds. Here, do you have any claims of money against others? They, try to get, you have a loan that you loan to someone and they're paying you money. This actually happened to me with a real estate transaction where I had did a real estate transaction where the individual held back, I think it was like $4 or $5,000, so we were able to make the transaction go through, and I was just paying him, uh, monthly payments on that remaining amount. This was something that was done years ago, uh, and this individual ended up filing bankruptcy, and I got a letter from the court telling me don't send him any money, to send it to the trustee. And so this is something similar where, if someone owes this individual money, they're going to try to figure out and see how much it is and have the payment sent to them to help with this judgment. And then it says, do you own or collect any kinds of coins, stamps, gun collection, stuff like that? Like this amount, it didn't show the amount on there, but for them to go into this much detail, this must be a hefty amount because you don't see them usually go into it this much. Asking for any money in a safe deposit box, for securities, cash, or valuables. Do you have any disposable property, or have you conveyed or disposed of any properties, gifts, otherwise in the past 2 years? The reason why they ask this statement is that in some states, like here in Wisconsin, if you are being sued and you lose, you cannot get rid of any of that property within a 6 month period of time before or after. That's the time frame. Looks like in Texas they have like this 2 year. I haven't seen it that long. Do you have any ownership in any business? Do you have any accounts receivable from that business? And then have you entered any transactions with your spouse or any relative involving a transaction? They're just trying to dig, and they got for any real or personal property in the last 4 years. What I would do is I would make sure that they're allowed to ask for this time frame. I mean, for that 2 year time frame and that 4 year time frame, I know in my state it's only 6 months. They might be digging a little too far. Let's see here. Nothing. Any pensions? Do you have any debts for which creditors state? They're just asking more questions here. This is like very detailed. So now let's get into how we would take care of this one here, because they're we'll mention state of Texas, and then I'll talk about other states that they can garnish. In the state of Texas, they can't garnish, so they're going through this detail to try to dig up dig up income or assets, all of that stuff. And I'm thinking that this is a business, individual that had a business, because of some of the questions that they're asking. So, step number one, you need to respond to this best of your ability, and then you should, and check with your clerk. I don't want to give legal advice on this, but check with your clerk and see if you have to turn this in before you turn in your request to have it reopened. Because if you can have it reopened, the outcome may be different, and yet you need to see what's going to be the reasons that you can have it reopened. If they serve properly, or if you disagree with the balances, there was a problem with the account. You got to come up with some reasons. Maybe you want to review all of the transactions. That's what I would ask. Um, I would ask to review everything that Calvary had. I would ask to review privacy informations that Calvary got from the original creditor. Like, you need to get all of that information and prepare a response to be able to fight in court. You need to review all of the documents that they sent in the original court summons, and then you need to make your case against them to get them to stop. If there's no way that you believe that you can win, and if they don't grant it, then you need to be looking at a settlement. And I would be trying to avoid answering this full statement and move quickly, especially if you have assets and you got cash and you got stuff. You want to avoid having to answer this. I believe that they're going through this because they probably had a default judgment and they're just trying to, make the individual answer these questions. Because if you start negotiation with any of these debt collectors, they're going to be more open to, let's talk about paying the money, and let's get away from the court with doing all of this stuff. Now, if you live in a state where you are able to be garnished, now the next thing you need to do is to look at the exemptions for your income to be able to be garnished, because you may not be able to be garnished depending on the amount of money that you make. In the state of Wisconsin, we have what's called a poverty guideline worksheet. It does not mean that an individual is in poverty. It just means that they don't earn a certain amount of money either individually or combined with their dependents, dependents. So you might have 3 or 4 children and you have a wife that's not working. All of those would be considered dependents, and they're going to allow you to keep a certain amount of income per dependent that you have. And it may take you out of the realm of being able to be garnished. It does not make the debt go away. You're going to have to deal with that another day. And we're also speaking of this as if you have a judgment, not where you're going to be fighting. But you do have that same opportunity to, if you just had a judgment placed against you, each state either has a 3 to 6 month window where you can ask to have it reopened, but you still got to have some good reasoning behind being able to get that reopened. Um, and then again, worst case scenario, which is still a good scenario, is that if you have they've won, it doesn't look like you're going to be able to get things overturned. I would immediately go into speaking to them about doing a settlement. You'd be very surprised on the discounts that they'll do, because their main goal is to get some money coming in. We just negotiated one where it started at $22,000, got it all the way worked down to 15, then the 10, then the 9, then the 8, and we're still working on that to get to 4 with a one-time payment. You better believe, because they're buying this money, they're buying these debts for pennies on the dollar. Yes, they want to maximize it, but if it doesn't look like they're going to be able to get anything with payments because of exemptions, because there's no traceable way of finding funds, uh, they will start listening to settlement offers. But you got to be very careful. You don't want to open the door on something that can get them jumping into your bank account and or taking your money. All right. If you need help with debt collectors, you have them coming after you. It's early in the game. You need to grab my 3 pack of letters. And you could at least stop them before it gets to this, because a lot of debt collectors, the reason why they get to this step here is because people didn't respond. They've done what's called a skip trace and they know that you have some sort of income, because they might see car payments and other credit card payments or other stuff that you're paying on. So they're gonna say, hey, this is a good individual to go after. But if you can stop them early, because if they look like it's going to be a challenge with dealing with you, because you're going to ask them questions that they are not used to people asking, and I'm going to give you that with the letters. The link is below here. You can stop a lot of debt collectors early in the game, and then I'm going to give you that letter to be able to stop them. Please make a donation on that, because just like in this case, it could have stopped this individual from having to pay, potentially pay a lot of money. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch video What Makes Us Different, so you can see my 8-point validation process, my 2-phase settlement process. If you need your credit reports and scores, grab those. The links are below this video. You can get your TransUnion, Equifax, Experian credit reports and scores. We also have a FICO score link, so you can see what car dealers, mortgage companies, insurance companies, credit card companies see. It's going to give you your FICO score. Also, if you have debt collectors suing you in court, third-party debt collectors, we have a link below where you can either learn how to respond to them the right way, or you can have us do it for you. Thank you for your time. Please subscribe to the channel. Please like this video. This is Stephen A. Williams, President and Founder of thecreditrepairshop.com.